right, we are ready to begin our pre-employment checks session, and I am happy to introduce James Buccini, who is the director of our pre-employment check, our criminal background check unit at the Justice Center. Take it away, Jim.
Well, thank you for the lovely intro, Davin, and good morning to everybody. I appreciate everybody that's participating this morning in the Pre-Employment Check 2024 Summit. You'll see some QR codes in certain slides, and I'll direct your attention to that. Those QR codes should take you to the information that we're discussing. And I will apologize to everyone beforehand. I didn't wear my coat with my elbow patches. I do apologize for that. We're still gonna try to sound professorly in this training. So without any further ado, let's get into it. So today's agenda, we're going to be doing a program overview. We're going to do we're going to talk about staff exclusion list checks. We're going to talk about the authorized person responsibilities, and we're going to close with criminal background check determinations. So first and foremost, folks that are participating here, your colleagues that are responsible for criminal background checks and pre-employment checks at your agency, if you do have questions, whether they be threshold questions, whether they be very specific questions, the Justice Center does maintain a very informative website. You could scan on the QR code. It would take you directly to the pre-employment checks section. As you can see, it's divided into staff exclusion list and criminal background checks. So you can, if you have questions about SEL, CBC, we do think that there is quite a bit of information there that can be found that could assist you in making sure that your pre-employment checks are done in the most efficient way possible. Okay. Who must undergo a pre-employment check? For staff exclusion list checks, any individual that the provider of service determines is going to have regular and substantial contact with individuals receiving service has to have a staff exclusion list check done. For a criminal background check, any individual that the provider determines is going to have regular and substantial unsupervised, unrestricted contact with individuals receiving service. Please note, unsupervised contact is not permitted until the results of the checks are received. Okay, who may request a check? An authorized person has to be designated prior to them having the ability to request either an SEL check or a criminal background check. Designation forms for becoming an authorized person can be found on the website. Could also be found on the drop-down menu from the criminal background check system. So if you're an existing authorized person and you're looking to designate other authorized persons within your provider of service, you can utilize the familiar drop-down tab in the CBC system and pull up the authorized person designation forms there as well. Okay, how do you designate an authorized person for the staff exclusion list? You're going to send in a completed form to the Justice Center with a sworn statement and the signature of the agency director. And we say the agency director for ease of use, but if you have a CEO, CFO, those are the folks that should be signing the designation form for an SF, for an authorized person to utilize the Vulnerable Person Central Register for the purpose of the SEL check. The authorized person, once the form is correctly submitted, will be granted access to the Vulnerable Person Central Register within 1 to 2 business days of submission. Okay, using the staff exclusion list check system, the authorized person will receive an email with links to the staff exclusion list online web form and instructions. I can tell you that the SEL web form may be one of the easier requests that you're going to make of all the pre-employment check requirements. It's simple to use so long as you have all of the required information, which we are going to be discussing. The web form we've made it as simple as possible for the authorized persons to use. That being said, If there are any questions or difficulties with the SEL check, in particular with the web form, please feel free to email us at the dedicated email on the screen at Staff Exclusion List Check. We, this website, excuse me, this email is monitored constantly during normal business hours, and we strive to get back to the folks with these questions as soon as possible, because we do understand that the folks out there are hiring, and that hiring is one of your more important functions in your day. We try to respond as quickly as possible to staff exclusion list checks that come, questions that come in. Okay, shifting gears. How do you designate an authorized person for the criminal background check system? You'll see one notable difference here. You do have to send a completed and notarized form to the Justice Center with a sworn statement and the signature of the agency director. We understand that notaries are hard to find nowadays. It's just the requirement under New York state law that the form has to be notarized. The authorized person will be granted access to the criminal background check system within 3 to 4 business days of the submission. I think I'm being cautious with that time frame. I do think that anyone that submits a correctly filled out form will receive their access before 3 to 4 business days of submission. Okay, once a person is designated as an authorized person for the criminal background check system, the Justice Center criminal background check system, the authorized person will receive an email with unique CBC system credentials, including a link to the login page. The CBC system is a web-based system, which requires a token for access for security reasons. You'll receive a link to the CBC login. You'll receive a user identification and temporary password, and the criminal background check user guide. The criminal background check user guide is something that the Justice Center CBC unit developed really with new authorized persons in mind, somebody that had never seen the system, never received any training, a new authorized person that's jumping in for the first time. My suggestion is really try to take a good look at the criminal background check user guide. It contains very helpful information on not only how to utilize the CBC system, but also the results that you're going to see through the system. So it's an important piece of documentation. It's available on the website, and you will receive it upon receipt of your system credentials. If there are any difficulties or questions with the criminal background check, whether it be the process of becoming an authorized person or utilizing the system, we also have a dedicated email box at the CBC. And again, as with the staff exclusion list, there is a recognition within the agency of how important these pre-employment check matters are. We strive to respond to any email request within same business day whenever possible. Okay, when you do have an authorized person, obviously that's going to change. People come and go. When the authorized person does change, we do need to have a current list of authorized persons in the CBC system. There are many times throughout the day that not only myself, but the attorneys that work in the unit, our other professionals, even anyone working in the unit may have at some point in time the need to contact the provider of service for any number of reasons. It's important that we have an accurate and current list of authorized persons that we can contact with important information. So once you become an authorized person, if there is a change and a person retires or resigns, it is the remaining authorized persons and the provider's responsibility to notify it of the changes to either the staff exclusion list or criminal background check authorized persons. It's very simple. You can submit the authorized person revocation form to the email address on the screen. We will get those changes updated as soon as possible. There are no notarization requirements. There's no signature requirements. Simply submit the form. Tell us that, authorized person A is no longer in your employ, and we will make sure that that person's credentials are revoked. It's very important to get this done, in part because this is a web-based system. Once a person receives a token to get in, they're in. The only way we get them taken out is to submit this form. So if you have potentially a disgruntled former employee and we don't get that person revoked from the system through this process, that person can really wreak havoc. They can go in, they can make changes to the CBC system. It is very important that as part of any provider's offboarding process, that they make sure that if the person is an authorized person for the CBC or for the SEL, that they be revoked as soon as possible. Okay, now that we've talked
Jim,
about,
there's been a few questions, so I just want to ask them if that's okay.
please, it's a
Okay,
good
great.
time.
The first question is, and you may get into this, but I think it's just a clarifying question. Is the staff exclusion list check required just one time or monthly?
Staff exclusion list check is to be done prior to the criminal background check, prior to employment. There is no requirement that it be done monthly,
It's just done upon hire.
correct?
Okay. And if an agency employs a student intern who is never alone with a person receiving services, do they need to have a criminal background check and a staff exclusion list check?
Questions like that, I would prefer to answer on a one-on-one basis.
Okay,
So please, to the person that asked, do not hesitate to contact us at the main number or email us at the CBC unit. We're happy to answer questions like that on a daily basis. Just here, I think it's a
Yeah.
little bit too
because
much.
you want to know more specifics about what
Right.
their contact is with people. So that's
Correct.
really to
A
make sure
lot of
they're in
people, a
compliance
lot
with
of
law.
people say there'll be no contact. However, when you get into it, there is always that potential. So I would prefer to have that conversation on a one-on-one basis. So please
Great.
contact us.
And the last question before you go on, how do we confirm that who our authorized person is at our agency, that we have the right people?
Please, you can look on the CBC system. There are reports that can be run, crystal reports that can be run to see who your authorized persons are. If there's any difficulty with that, do not hesitate to contact us. Anyone in the CBC unit can send you a list of your current authorized persons. We could also give you guidance on how to get to that screen to check for yourself.
Okay, great. And just before you get into staff exclusion list, because these just came up, if somebody leaves, the agency for another job and then comes back a couple months, a couple years later, does a staff exclusion list check still need to be done? Because they
Yes.
worked, yes. All right, very good.
Absolutely.
All right,
I would say that when contemplating a staff exclusion list check, please do so. Please, if you feel the need to do a staff exclusion list check, do it. It doesn't cost anything. Just go ahead and do it in situations like that where people have left and come back. It might be, even if it's questionable whether a criminal background check is needed, I would strongly suggest to the providers out there that staff exclusion list checks be done. And if there are ever any questions about whether one is required or not, do not hesitate to contact us. We will get back to you and have a discussion.
all right, carry on, Jim.
Great segue into staff exclusion list checks. As we just stated, staff exclusion list check is considered a fingerprint prerequisite. A staff exclusion list check must be completed prior to registering someone for fingerprinting. The authorized person is required to certify that the staff exclusion list check was completed. And what that looks like is prior to an authorized person going in and registering someone for a criminal background check in the Identigo registration system, which we are going to talk about later on in this training, there is a screen where it states, has a staff exclusion list check been done? You have to check a box attesting to the fact that it's been done. If you check the box, we assume that you did it. We allow you to move on to register your person for a criminal background check. Now, it's not an uncommon situation for either ourselves or for the state oversight agencies to uncover that those boxes have been checked and staff exclusion list checks have not been done. We've got a lot of people in this training today. We have a lot of people in the trainings that we do on an annual basis with the state oversight agencies. If you've taken the training, don't be the authorized person that doesn't get the staff exclusion list check done prior to getting the criminal background check done. It's imperative that the SEL check be done. I cannot overstate the fact that part of the reason that the Justice Center is here is because people can be found to have engaged in serious and repeated abuse and neglect situations and not incur a criminal conviction in New York State. So just not, if an individual has no criminal history, that cannot be relied upon to assume that they're not on the staff exclusion list check. So please make sure that the staff exclusion list check is done. I can't stress that enough. So how do you check the staff exclusion list? An authorized person can review the staff exclusion list, check job aid. If there are any questions on that, I can tell you that it's very, very self-explanatory. If I can do it, I trust that all 500 plus people on this training can do it. Seek additional guidance on our website and submit the staff exclusion list check online via the aforementioned web form. Again, you'll be upon designation as an authorized person for the staff exclusion list, you will be provided with a link to the web form for submission. So what do you need as part of the information for the web form? Social security number is necessary. Submitting an online check requests a social security number or an alien registration number. Again, we understand that you may encounter a candidate for employment that you look to hire that has neither. So if an individual has neither a social security or an alien registration number, you are required to initiate a manual staff exclusion list check using the SEL check form for applicants without a SSN. And I understand when we do these trainings, a lot of people are concerned with the transmission of a social security number. This is not a Justice Center controlled requirement. This is something that is required in New York state law. So if your individual that you're seeking to employ has a social security number, we absolutely need that to effectively complete the staff exclusion list check through the Vulnerable Person Central Register. Batch requests. Providers may submit batch requests for up to 100 applicants using the staff exclusion batch check template. I'm not going to try to say that 3 times fast because it's very hard to say. The point is, providers can submit requests for multiple individuals. So if you're hiring multiple folks for the, for a position, feel free to utilize the the batch check template. Okay, if you're an authorized person and you've submitted the web form, you've got all the pertinent demographic information down. The online check is going to generate a unique confirmation number. Okay, I think it's a 16-digit alphanumeric combination code. The authorized person will receive this response within 1 business day. When we do this training in person, which it's been a while, and I miss it, quite frankly. When we do this training in person, I always ask the participants how long, for our authorized persons, how long these responses take. And I usually get a response that the vast majority of them come back within 10 to 15 minutes. So again, when you have a candidate in front of you as part of your onboarding process, when you've made the decision that you want to hire this person, you can do the staff exclusion list. And for the overwhelming majority of the folks that are in front of you, you're going to receive that response probably while you're collecting demographic data to register them for the criminal background check. So the responses come, the experience of the providers that have participated in these trainings is that the responses come back very quickly. And you will receive a response from the vpcr.notification website or email. Okay.
Jim, we have just a couple questions.
Sure.
Just to confirm, one person wanted to know, what if an employee leaves the agency and they come back within a month? Do they still need to do a staff exclusion list check?
It really depends on the circumstances. I would suggest that they do it.
For the very reason that you said before, in that time period?
In that time period, anything can change.
Yeah.
we've had experiences where we've had calls from individuals asking about their status on the SEL. And we give them one answer and then it changes because they have a placement. It's, things can change very quickly. And if somebody leaves and comes back, I would err on the side of caution if I were a provider of service and I would put in the SEL check request.
Okay, great. And one person wanted clarification. Everybody who has a criminal background check also needs a staff exclusion list check. I think this provider has co-located, so they've got a staff person that might be working in 3 different settings that are licensed by the 3 different, O agencies, the Office of Mental Health, do they need to get a separate criminal background check?
So that at this point in time is a very tricky question. There's a new law in place, Mental Hygiene Law 3602. We are currently putting the infrastructure in place to facilitate one criminal background check. However, we're not quite ready to get the education out on that. So there's something that's going to be coming very soon that will answer that question. If you would like more information on it, please don't hesitate to contact us. In fact, I've got a few folks out there that we've been communicating about this. So the infrastructure is going to be put in place very soon to address some of those issues.
Okay, 2 more questions and then I'll let you on. Just clarify again, if someone is on the staff exclusion list, can an agency hire that person?
No.
All right. And does the AP, the authorized person, receive a unique confirmation when they do batch requests?
I believe so, yes. They will receive a unique confirmation for each individual.
Okay, thank you.
Right. Thank you. I mean, I really appreciate the participation. These are great questions and they're enhancing the training. So thank you. Okay, moving on to authorized person responsibilities. So we're going to talk about 6 things here. Checking the staff exclusion list, which I reiterate again, must be done first when you determine that a person is going to have regular and substantial contact with individuals receiving service. Providing the applicant with certain information, registering the applicant for fingerprinting, updating the employment status in the CBC system, always an important topic, maintaining all applicant records and information, application records and information, and ensuring that the provider has a criminal background check policy to implement the statute and regulations. Okay. We've already talked about the SEL, so we're going to go right into the information that you have to collect from the applicant or that you have to give to the applicant. As an authorized person, you have to ensure that the applicant completes the consent form for fingerprinting. Now, I'm going to give you a caveat here. We have supplied the Justice Center's consent form for fingerprinting, which contains all of the information that allows you to be you as an authorized person to be in compliance with New York State law, New York State Executive Law 553. So if you utilize the Justice Center's consent form for fingerprinting, I think it's been universally accepted by all of the state oversight agencies as containing all of the appropriate information to show that you've complied with the law. So my suggestion would be utilize the consent form for fingerprinting prior to registering a person for a criminal background check. That being said, if you feel like you have a better form that complies with the law, by all means, go ahead and use that. Also, as an authorized person, you are required to provide the applicant with the personal criminal history information review form. Same thing with the consent form. This is a form that the Justice Center created to be compliant with New York State law, which requires that you, the authorized person, provide the applicant with information necessary for them to challenge the results of the criminal background check if they see fit. We've created the personal criminal history information review form to do just that. My suggestion as part of your onboarding process, if you're responsible for the hiring at your provider of service, print out 500 copies of this, leave it in a stack at your desk. And if you even think about sending someone for a criminal background check, make sure that they walk out of that room with the personal criminal history information review form. If they've walked out of the room with that form, you have complied with New York State law. Okay, registering an applicant. complete the fingerprint applicant information sheet. I know that looks like a directive. It's not meant to be that. The fingerprint applicant information sheet is a document that the Justice Center created for ease of use of the providers, or for the authorized persons, excuse me. It contains the information that is necessary for you to collect as an authorized person to most effectively register a person for a criminal background check through the Identigo website. I can tell you, when we hire staff here at the Justice Center, the first thing that I do is I send them the fingerprint applicant information sheet. I tell them to fill it out and fill out everything, so that when I sit down and register that person through Identigo, I have all the information I need in front of me to do that. How do you register besides collecting the fingerprint applicant information sheet? You register for fingerprinting with Identigo online, or by calling the number on the screen here. In all the years we've been doing this, I always ask in the trainings, if anyone has done this by phone, I would love to hear about it. I'd love to hear about your experience. Please contact us at the main line. You'll see the number at the end of the training. Let me know how it went. Obviously, the vast majority of people are utilizing the Identigo online registration process to register applicants for fingerprinting. Okay, some of the required information for a successful criminal background check registration. Current address, very, very important to get us the most accurate, up-to-date, and complete address for an individual. There are times, and we'll see this later on in the training, there are times that the Justice Center is required to reach out directly to a subject individual. We have to have a current address. A post office box is insufficient. Please, when you're sitting down with someone as part of your onboarding process and your registration process, please, please, please get the most current and accurate address possible. It will save us a ton of time in the long run if it's an individual that we need to get in touch with. Demographic information, again, always a little bit of a sore subject, because you do have to get some physical information from an individual. The reason that you need it for the registration process is for the benefit of the live scan operators, where the person is going to go get fingerprinted. The live scan operator is going to look at that person and utilize the demographic data that you've provided to make sure that it is the same person that you sent for fingerprinting. Okay? If you have a candidate in front of you that has potentially a criminal history that may make them unsuitable, you certainly don't want that person sending their friend or cousin or whoever it is that has no criminal history, and the results come back on that person rather than your candidate. So again, it is very important to collect the appropriate demographic information on individuals through the Identigo registration system. And finally, required information, specific job duties. I think we're go to the next slide for that. The authorized person must provide specific job duties, including how an applicant will have contact with folks receiving services at your provider. As you can see, we've put a screenshot up here of what the job duties registration looks like. It's a free text box. This is a sample job description, which I know after we do these trainings, we see a lot of these, and that's fine. This is a little bit on the nose. The applicant will have regular and substantial unsupervised contact with individuals receiving services in a direct care setting and will assist with activities of daily living. This is a great example of a good job description that will assist us in the long run in making an appropriate determination on an individual's suitability for employment. So it's very important that, we've seen these range from a simple letter, a number, or somebody says maintenance or porter. We need more information than that, not only to show that the person is actually a subject individual for whom fingerprinting is required, but also we're utilizing this to make a threshold determination in our correction law Article 23A analysis as to whether or not a direct relationship exists between the nature of the criminal history and what the person is actually going to be doing. So giving us a substantive, accurate job duties description will always help us in the end to make the best determination for you, for the provider of service. Because each determination we make is unique to a person's, if applicable, criminal background, and whether or not a direct relationship exists between that and what the person is going to be doing for you. So please provide us with the most accurate job duties summary as possible. Okay, all that being said, providers may still be looking for guidance on how to register somebody, on what they have to provide, all of that good information. The criminal background check guidance and resource section of the website provides, among many other things, fingerprint registration guidance, also identical links and service codes for OMH, OCFS, and OPWDD. For the folks participating today, those are the 3 state oversight agencies that, pursuant to the Protection of People with Special Needs Act, are required to do the criminal background checks through the New York State Justice Center. Each provider has their own unique service code. The service code essentially will ensure that the results of the criminal background check come to us through the right ORI, and I'm really going to avoid getting into technical issues about e-justice today. So if you do have a question about service codes or questions about multiple providers, that's something that we can discuss, if you give us a call or send us an email. But if you do have a question as a new authorized person as to what your service code is, the website has that information. Okay. Record retention rules for
Jim?
authorized person. I see Davin popped up. So
Yeah, we've had a number of questions, and I seems like this might be a good before we get into record retention. So should you do a staff exclusion list check for somebody who's working in an administrative position in the agency? In provider agency?
It's up to the provider to make that determination as to whether or not the person is going to have regular and substantial contact. That's the statutory requirement. So if you believe that a person that's going to be doing administrative tasks or clerical tasks could have the possibility to have regular and substantial contact with the individuals receiving service, then yes, you would have to do a staff exclusion list check.
Okay, and we have several OASAS providers on, and they're all very
Hi,
curious. Wait,
OASAS.
what about the OASAS background check? That wasn't on the slide. Who checks them? So can you clarify?
OASAS actually has their own statutory authority under mental hygiene law 19.20, 19.20A, and they have a fantastic criminal background check unit at OASAS that we work with very closely with criminal background checks. The OASAS folks, I'm glad you're here. We welcome you. And you, as you know, you utilize the criminal background check system. So you do have your own entity that OASAS does their own criminal background checks. The Justice Center does not have a real role in doing that until we get the infrastructure in place to implement mental hygiene law 36, which will allow for one fingerprint check and one result. So glad you're here. Thank you for participating.
Next question, can anyone but an authorized person check the staff exclusion list?
No.
Okay. There were a number of questions about the personal criminal history information review form. Is that?
I can address it generally. The personal criminal history information review form, it's hard to say without seeing it on the screen, by the way. But the form is, we created this form based on a statutory requirement that the authorized person provide any individual that's going to be fingerprinted with information on how to challenge the results of their criminal history. So what we came up with at the Justice Center was a form that does that. So if we report a criminal history on an individual and they say that's inaccurate, I never had that conviction, the Justice Center is not going to research that. That's not our role. What has to happen is, if they believe that their criminal history in New York State is inaccurate, they would institute a record review with the Division of Criminal Justice Services. The personal criminal history information form provides that individual with steps on how to do that. Likewise, if a person feels that there was something that happened outside of New York State that was identified in their criminal background check that's inaccurate, the form also provides them with guidance on how to get in touch with the FBI to challenge anything that came back on their FBI identification record. So that's what the personal criminal history information form is. We try to make it as simple as possible. Anytime you're even thinking of doing a background check for somebody, a criminal background check for someone, make sure that they are in possession of that document. You've fulfilled your obligations if you've done that.
And this new law, when it's passed, that means that employers they won't have to do separate checks if they have employ people across programs from different agencies, like different licensing agencies.
Between OASAS and the Justice Center. Yes, that was the purpose of the new law. And again, it's something that unfortunately it can't happen overnight. We have to have the infrastructure in place, including newly issued e-justice ORIs to get that done. And that is something that we're working on right now with both the Division of Criminal Justice Services and the FBI. FBI approval is necessary.
Okay. And you were very detailed about, filling out a detailed job description, what the person does and their contact with people. Does that mean that a provider agency must also put in a person's title and department?
Absolutely not. A title and department is not helpful for us. We'd rather you utilize the limited free text space that you have to tell us what type of contact they are going to be having with the individuals receiving service.
Okay. With the criminal history form that, you give to, that you suggest people give, do providers have to document that they gave that to a prospective applicant?
Well, that's more of a question for the state oversight agencies that oversee your statutory and regulatory requirements. If I were an auditor at OPW or OMH, I would hope that that would be on part of your onboarding process. If I saw that in policy, I would assume that you're complying, but I think that's it's a provider by provider question there as to how you document that.
Okay. Someone wanted to make sure to ask if the monthly Medicaid staff exclusion was checked. That I think is that maybe required by OMH providers. I haven't really.
I can't speak to that.
That's different than this is just the Justice Center staff exclusion list check. So, and that has to be done. Finally, is the state central register check going to be discussed? And do we handle that, Jim?
The state central register is not going to be discussed. It will only be discussed to the extent that we provide you with the best phone number that we believe we currently have for the Office of Children and Family Services. We do understand that the SCR is required as part of the Protection of People with Special Needs Act, but the Justice Center has absolutely no pre-employment role with the staff exclusion list check.
All right. Thank you. Very good.
To the extent possible, that's all we're going to talk about it today. Okay, back to the record retention rules. These are the documents that New York state law requires that you retain as part of your pre-employment check process. The applicant consent form that we discussed, the criminal background check results, and the subsequent arrest notifications. And you notice the asterisk, which we will talk about before we get off this slide. These documents must be maintained for the purpose of state oversight agency audit for a period of 6 years after the subject individual is no longer employed or volunteering. So once you go in and do the update that the person is no longer a subject individual, no longer in your employ, that's when the clock starts running on the 6 years. Now, to make this as easy as humanly possible for our authorized persons out there, because we know you have so many other responsibilities with pre-employment checks, the criminal background check results and any subsequent arrest notification that you receive on a subject individual are saved within the criminal background check system and can be brought up and reviewed by authorized persons within a few keystrokes after signing into the CBC system. So what I'm saying here is there should be no need to print out criminal background check results or arrest notification results those are confidentially disseminated, that those things contain confidentially disseminated information, and putting them in a physical form is something that we would not suggest. And part of the reason we suggest you don't do that is those things have to be maintained in a confidential manner, preferably a locked cabinet, which only the authorized persons have access to. It is much easier to allow these to just be maintained in the CBC system for review by duly designated authorized persons. So we try to make it as easy as possible. We can't do that with the applicant consent forms. But these are the documents that you as an authorized person have to retain relating to the pre-employment checks. Okay, a topic that I promised we'd discuss, it's important, is the authorized person's responsibility for updating the employment status of its subject individuals. The authorized person must update the employment status of any subject individuals in the CBC system within 14 days of any change. So we'll make it very simple. The vast majority of the folks that you fingerprint, you're going to get the SEL, you're going to fingerprint them. And we'll talk about this when we get to CBC determinations, but the overwhelmingly vast number of folks for whom you request a criminal background check, you will receive a result within 1 business day. When that person's results come in, there is a corresponding entry for that individual in the criminal background check system. And as the authorized persons know, when you have access, you can go in there and change certain things. This screenshot here is the employment status screenshot. And the reason that we have applied highlighted here with a nice red arrow is because any individual who's been successfully fingerprinted and whose record goes into the CBC system is going to default to applied. Okay, so if you receive your results, you've done all your pre-employment checks, and you're looking to hire me, I don't know why you would, but if you were, and you received the results and the hire date for me was May 1st, 2024, you've got 14 days. So by the 14th, you would be required to update the CBC system from applied to hired as a subject individual. Likewise, you find out I'm a terrible employee within a month. June 1st, June 1st, you fire me. You have until June 14th to update the Justice Center CBC system's employment status from hired as a subject individual to no longer employed as a subject individual. And as I suggest to all the groups that we meet with, please make this a part of both your onboarding and offboarding processes at your provider of service. It makes things a heck of a lot easier. Updating the employment status has so many downstream benefits as far as criminal background checks are concerned, as far as auditing is concerned, that you are going to want to make this a highlight of what you do on an everyday basis and part of your procedures.
Jim, I'm sorry, but there's been several questions about the 14 days. Like, what happens if I don't update it within 14 days? What happens if I'm still waiting for other background check clearance, like maybe the SCR, so I can't, make the final decision to hire, and I can't upgrade to, accepted for service or whatever.
So it's important to note that the 14 days does not start running until there is an actual change in status. So if you are awaiting other components of a pre-employment check and you haven't actually hired the person, the 14 days don't start. The 14 days do not start running until you've actually had a change in the status from applied to either hired or not hired. Likewise, when a person is either terminated or they leave, you've got 14 days from that actual date. I don't know if I answered all those questions.
I saw some thumbs up, so I think you did answer those questions.
All right, great.
So
We love
carry
the
on.
thumbs up. Thank you. Okay, the last piece of information that we're going to talk about the authorized person's responsibilities, as if you haven't had enough already, is that it is the provider's responsibility to maintain a policy designed to implement the statutory requirements and the regulations for pre-employment checks. So each provider shall have a policy. For your consideration, we have created a draft sample policy and procedure on our website. If you are a provider of service that does not currently have a policy, I would suggest going on the website, taking a look at the policy that we've created. It is a bare bones policy. It really is as simplistic as we can make it. The expectation would be that it would be a starting point for any provider that has to do background checks and that does not currently have a policy in place. Obviously, you would have to revise it to suit your provider's unique needs. But the takeaway from this is if you don't have a policy, we have a draft sample policy online that is really what we believe a good jumping off point for the providers. And I think with that, we're at our 5-minute break.
One quick question before we go on the break.
Absolutely.
The staff exclusion list confirmation email contains, date of birth and stuff. Where should a provider agency store those?
I think that that's up to the provider agency on how they store those.
Thank you.
I would maintain them for the purpose of being able to show a state oversight agency compliance. We do, however, have other dashboards and things, technological solutions to show that the providers have done the staff exclusion list check. I would say for your own purposes, the provider should determine how they handle that.
Okay, thank you. Jim, I just have a couple questions came in over the break, and I want to put these people at ease. Can an agency hire someone if the criminal background check has been completed, the staff exclusion list has been completed, but they're waiting on the SCR check? Do they have to wait for that to be completed?
Unfortunately, I can't provide a definitive answer. That has to be provided by your state oversight agency that's auditing you for compliance.
Yeah, I think
Justice Center, we just can't provide you with an adequate response on that. It's not our jurisdiction.
Right. Very good. And then there's a lot of concern about the 14-day rule because it can take longer than 14 days from the time they submitted, the SEL or CBC check. So if, is it 14 days that they have to put it in from the date that person was hired or from when they submitted the check, the change in status?
It's from the date that the person's employment status changed, but it's put it in normal human terms. It's from the date that the person is hired. So if you start the criminal background, if you start the SEL, criminal background check, mental hygiene law 1634, all those checks, if you start them on April 1st and you do not complete that process until April 15th, and then you hire the person on April 16th, you've got until April 30th to update the system. The date does not start running at the time that you start the process. It starts from the time that you actually hire the person.
Okay.
Hopefully that helps.
Great. And then there's a lot of records retention requests, specific questions. So I'm just going to ask the people who have those questions, where do I store these documents? What about if it's longer than 6 years? What if I'm audited? I think that's a good reason to contact the criminal background check unit and ask those specific questions that you have. So that's it. I'm gonna let it go.
Right. Thank you. Again, the participation has been wonderful. I really appreciate it. I appreciate the opportunity to answer your questions. But if you do have anything specific, please feel free to reach out either via email or by phone to the CBC unit. We have multiple attorneys in the unit that can answer all of your questions. We have a number of staff that can answer any questions, be it administrative, legal, whatever it is. If you do reach out, you will get an answer to your question. So again, love the participation. Please keep them coming. We're moving on to criminal background checks criminal background check determinations. We're also going to be talking about important status updates that the authorized persons are going to be seeing. So let's jump right into it. Types of criminal background check determinations that you're going to see. These are considered the not denied, which would be accompanied by something, which we're going to talk about specifically in the upcoming slides. You may get a criminal background check determination of held in abeyance, and you may receive a determination that an individual that you've submitted for a criminal background check has been denied employment. We'll talk about these things. We'll talk about the numbers and the metrics as we go through each of these. The statutory authority is mental hygiene law, social services law, executive law 845B is our procedural statute, and our regulation is part 701, which you can find a copy of on the Justice Center website under laws and regulations. So let's jump right into it. Okay. The first and most common by far type of determination that an authorized person is going to receive is not denied. Okay. Not denied non-ident, not denied no criminal history. What does that mean and what are the numbers? So let's go over first the numbers. In 2023, for OMH, OCFS, and OPWDD providers of service combined, we fingerprinted over 106,000 people in 2023. 87 to 88% of those people, and this is on a yearly basis, this figure almost never changes. 87 to 88% of the people that are fingerprinted are going to come back with a determination that says not denied, either non-ident or no criminal history. Okay, so a large number. So if you fingerprint 100 people in 2023, 87 or 88%, 88 or 87 of those people are going to come back with a result that shows on this screen of not denied non-ident, not denied no criminal history. This means that for a non-ident, the person has never actually been fingerprinted, either civilly or criminally. Or in the event that you receive a result that says not denied no criminal history, it just means that the person has no reportable criminal history. You may move forward in the pre-employment check process to consider these individuals for employment. So as we go through the remainder of these slides, please keep in mind the vast majority of the folks that you fingerprint, we've already talked about on this screen. Okay, very important to know that. Okay, you may receive a result that says not denied criminal history. Okay, so you may get a notice, as our authorized persons know, when we update the CBC system with our determinations. You're going to get an email saying there's an update that the person has been cleared for your consideration for employment, that they were not denied, but that they have a criminal history, and that criminal history is contained in a correspondence that's been uploaded to the Justice Center's CBC system. Okay, so the New York State criminal history is shared. Without getting into too much detail, because I could spend the next hour on this, the Justice Center and every entity in New York State that is required to do background checks are prohibited from sharing any criminal history from outside of New York State. Okay, this is not something that the New York State government has come up with. This is not a Justice Center requirement. This is directly from the federal government, from the FBI. The Justice Center and all other fingerprinting entities in New York State are prohibited from sharing information that we receive on the FBI identification record. Now, it's important to note, we receive the information, we utilize it as part of our determination process. Unfortunately, we are prohibited from sharing that with you, and that's been since a civil audit was completed by the FBI of all fingerprinting in New York State in 2011. So this is not a new thing. What we will do and what we can do is that we notify you that there is something that occurred outside of New York State that has been considered by us as part of our analysis, and that we've made the determination that regardless of that, the person's cleared for your consideration for employment. So if it is the provider's policy, for example, to receive the results and then go back and talk to a person, you are going to have some notification very clearly stated on the determination letter that the decision that we made to clear the person for your consideration was based on, at least in part, on some criminal history that occurred outside of New York State. And this also includes convictions from federal court. So we will notify you, but again, we can't specifically share any information that we received from the FBI identification record. And I'm sure there's going to be a lot of questions about that. To the extent possible, if we could hold off on those questions, we could probably answer them at the end. But I do know that it's a cause of concern for a lot of providers. there's just nothing that the state of New York can do about it. We've been expressly prohibited from sharing that information. But back to the actual determination that you as an authorized person are going to see. You will get the entirety of the New York State criminal history, and you will get a very clear notice that the criminal history has been reviewed. A correctional Article 23A decision has been made and documented, and that you can move forward and consider this person for employment. An example, you have a candidate who's been convicted of petit larceny in 1997. You are going to receive notice that they've been convicted of petit larceny in 1997, and you're going to get a communication that indicates that you can move forward with considering that person for employment. Okay, you may get a determination, although this has become increasingly rare with changes in the way that criminal histories are reported to state agencies. You may get a determination that says not denied insufficient court supplied information. All this means is that the person was arrested, charged with a crime, and the court of jurisdiction has failed to provide a disposition to the Division of Criminal Justice Services. And as such, we are seeing the arrest on the individual's rap sheet. Now, it's important to note the Justice Center CBC unit takes painstaking efforts to make sure that the information that we provide to you is as accurate as possible. So when we receive a rap sheet that doesn't contain a disposition, and we believe that it should, we exhaust our administrative remedies to contact law enforcement, the courts, whoever it may be, in an effort to perfect the information on that rap sheet. Okay. We are successful the vast majority of the time. However, there are times where we cannot get that information. A couple of examples: a flood destroyed the barn where the court records were maintained. Mold has destroyed the records. Believe me, we've heard everything. In those instances where we would not consider a denial for that person's charge, we are going to notify you of the charge on the record, and we're going to tell you that the person is cleared for your consideration for employment. Please understand that we will not send you a notification that an individual has been charged with sexual assault or attempted murder and tell you that there's no disposition. You can go ahead and review that. We will get into what we do in those situations a little bit later when we talk about the status updates. But keep it on track here. If you receive a notification that says an individual is not denied and there's insufficient court supplied information, the communication that you receive in the CBC system will be very clear about what we're seeing and the reason why we're seeing it, so that you can proceed accordingly with your pre-employment check process. Okay, you may receive a determination that the subject individual is not denied, not held in abeyance. What this simply means is that the individual's criminal history record came to us showing a legitimately pending criminal charge, and the applicant may be considered for employment. So I'll give you an example. We receive a criminal history record check result that shows that your candidate was arrested and charged with petit larceny for stealing a candy bar in April of 2024. What the Justice Center will do is we'll look at that open charge. Petit larceny is a misdemeanor offense. If we determine that there is no direct relationship between the elements of the crime for which the person has been alleged to have committed and the position sought, we are going to clear that person for your consideration for employment. We're going to notify you about the fact that there is a pending criminal charge, but we are going to tell you that you can move forward and consider this individual for employment. Now let's contrast that. We talk about the status update. I hesitate to call this a determination because it really isn't. It's more of a status update. But the Justice Center does have, in certain circumstances, discretion, and in certain circumstances it's required that we actually hold the criminal background check process in abeyance pending the outcome of a criminal case. And we'll jump right into that. So if you, as an authorized person, receive a notice stating that an application is being held in abeyance, it's one of two scenarios. If the individual has a pending felony offense on their criminal history record result, the application is required to be held in abeyance. The Justice Center has no discretion whatsoever under Executive Law 845B. If your candidate's criminal history record shows a legitimately pending felony offense in a court of jurisdiction, either in New York State or outside of New York State, we are required to hold the criminal background check process up pending the outcome of that charge. Okay. Now, if you receive a notification that the applicant is held in abeyance and because they have a pending misdemeanor offense, the Justice Center does retain discretion in the instance that in the event that the person's criminal history record comes back showing a pending misdemeanor offense. Okay. And without getting into too much detail, if the person's results came back, I'll utilize an example. If we receive results from your candidate that shows that they were charged with a domestic violence assault crime, the Justice Center may look at that, complete the required analysis, and determine that that misdemeanor offense, that we have to hold the application in abeyance pending the outcome of the misdemeanor offense. What's important to note, if you receive a notification that the applicant is held in abeyance, you should have a little red flag go up when you see that. And understand that at this point in time, the applicant is not eligible to be hired in a direct care position because the Justice Center has just held the criminal background check process up pending the outcome of some criminal charges. So the obvious question is, I'm an authorized person. What do I do? In the event that you receive a notification that the applicant is held in abeyance and you do not want to hire the person, we ask that you go into the Justice Center CBC system and you update the employment status to application withdrawn. That ends the criminal background check right there. If the candidate sends us letters and documents, if you've updated the application withdrawn, we're going to take them and throw them away because the person no longer is a subject individual. Okay. Now, let's say you receive a notice that says the individual is being held in abeyance and you want to hire them. I'll use a great example. Let's say they were charged with grand larceny, 3rd degree. And you get that, and that's not something that's of concern to you. And the person has clearly stated to you, and you believe them, that their attorney told them that that charge is going to be dismissed next week. Because it's a felony offense, we're required to submit a notice indicating that that person's held in abeyance. You want to hire them. What you have to do is work with the candidate. Okay. Make sure that when that person goes next week with their attorney to court and they process the dismissal of that charge, that that person obtains a court disposition document. They're going to have to pay $10. I think it's $10. I don't know if it's going up, but they will have to pay the $10 to get a sealed certified court disposition. That is an official document that has to be submitted to the Justice Center so that we can move forward in the process. And I think I may have, nope, I didn't. I thought I jumped ahead, but I did not. So in the instance that you as the authorized person receive a notification that the person's held in abeyance and you still want to hire them, you have some work to do. You work with the individual. You, as the provider of service, get the court disposition, send it to us as per the very concise and explicit instructions on the notice that you'll receive on the person's record in the CBC system. Okay. And again, if you don't want to hire, update the application withdrawn. If you do so and the person starts submitting information to us, we're going to know that the person is no longer a subject individual, and we will treat that documentation accordingly. We'll ignore it. Okay. Moving forward to the unique circumstance that an individual is actually denied employment based on the nature of their criminal history. This is, to be clear, a final determination that you may receive. To put it into perspective, as I stated earlier, we fingerprinted over 106,000 people last year between OMH, OPW, DD, and certain OCFS providers. We processed 380 denials out of 106,000 people. So, if anybody here was a math major or are good with numbers and they want to put together a statistic of how many people overall have been denied, I would love to know what it is because I always say it's like 0.0003%, and I don't know that that's accurate. I became a lawyer because I couldn't do math. But if we have a math person out there that wants to figure that out, I would love to know what the actual number is, and maybe Davin can at the end report that to us. Okay, all joking aside, if you receive a determination of denial, you may not hire the applicant in the direct care position for which the criminal background check was requested pursuant to the requirements of the enabling statutes of New York State. So when you decide that a person is going to have the statutory level of contact with individuals receiving service at your provider and the person is denied, they may not be hired for that position. Okay. You will be notified of the decision, just like the other previous decisions, via a correspondence uploaded to the criminal background check system. Okay. Now, a little bit different. The New York State law does have certain requirements that attach for the provider when you do receive denial. Again, the vast majority of our providers of service will never receive a denial. However, if you do receive a denial, it shouldn't come as a surprise to you. We're going to talk about some of the procedural steps that occur prior to receiving a denial. But once you receive a denial, it is your responsibility pursuant to New York State law to notify the applicant, A, that the employment was denied, and B, that the criminal history was the basis of the denial. Essentially, you're telling the person that the Justice Center denied your employment based on your criminal history. So it is your requirement under New York State law that you do that. Okay. That's number one. Number two, less likely of a scenario that is a requirement. You as the provider of service, upon written request from the applicant, are required to furnish a copy of the reported criminal history summary. I'm assuming that this doesn't happen a lot because to get to the point of a person being denied, they've already been provided with a summary of their criminal history and a summary of their full criminal history, not just the New York State criminal history. They've been provided with a summary of the criminal history. We don't even get to the point where we deny an applicant for employment until we know and have documented proof that the person has received their criminal history summary. So I think that the second paragraph on this slide is probably hasn't come up very often. The important thing to note is that it is your responsibility to notify them and notify them in a timely manner. This is necessary because the person, certain rights attach. When the Justice Center says no, when we say no to somebody and we deny their application for employment, their right to challenge our determination immediately attaches. They need to be provided with notification that this occurred so that they can weigh their legal options. So it's very important and it's a statutory requirement that you do that. So please, to the extent possible, make that part of your pre-employment check process in the event that you do receive a denial notification. If you have any questions and you receive a denial, do not hesitate to contact us. I will talk to you about it personally if there's any questions. Okay, so we've talked about decisions. We're now going to talk about status updates. This is probably the most, in my opinion, most difficult part of the training to comprehend. So if anybody's been sleeping or diligently doing their own work and have this on in the background, I would ask all of our authorized persons to pay attention. Along with determinations, and again, just to put this into perspective, when we talk about status updates, we're talking about probably less than 1% of the people that you're fingerprinting in any given calendar year. It's okay. So if you see an update in the CBC system for your candidate that says none being processed, what that means is there hasn't been a determination made by the Justice Center. The application is being processed. Okay. So if you are an authorized person and you see this and your first inclination is, let's call the Justice Center or let's email the Justice Center and ask, I saw that the update's none being processed. Can I hire this person? The answer is going to be no. You can't hire this person. You have not received a determination clearing them for your consideration. What this means is one of two things. Okay. And again, when you see none being processed, I want a red flag to go up in your head and understand, one, that there has not yet been a clearance, and two, that there may be more work for you to do. Okay. What none being processed means is that a determination has not yet been issued on the applicant's suitability for employment. And you have to understand that at this point in time, while that person remains in none being processed status, the provider may not hire the applicant in the position for which the criminal background check requested. And you have to keep in mind that you may only move forward with a hiring decision if and when a determination has been issued for the applicant. The if, a little bit foreboding about what we're going to talk about in a few minutes. Okay. So again, none being processed. To be clear, that is not a final determination. When you find that, or when you get that status update, red flags should go off in your head and understand that you may not move forward at this point in time. Okay, we are processing it. Sorry. Okay, there are two scenarios in which an individual's record can be updated to none being processed status update. One is something that we briefly touched on. The applicant's criminal history result includes a criminal charge for which the criminal background check unit cannot determine the disposition, and that we have had to reach out to the applicant to provide disposition information on the charges. What we do in a scenario where criminal history comes back, and it happens enough that we have to address it here. When a criminal history comes back and there is a charge for which we cannot perfect through normal administrative means, and has a charge for which may result in a adverse employment determination, we reach out to the applicant for assistance. Okay. When we do that, when we send that letter to the good address that you've provided to us, we're basically telling the applicant, your rap sheet came back and shows a charge for first-degree rape in 1994 in the Monroe County Court, and we cannot get the disposition. To move forward in the process, we are requesting your assistance in obtaining sufficient court-supplied information that shows what the disposition of that charge is. It happens more often than anyone in New York State would care to think that we see these things. Normally, we are able to procure sufficient information to allow us to move forward with the process. The charge has been dismissed, was never prosecuted, whatever it may be. In the rare circumstance, and I'm going to tell you just how rare it is, in the rare circumstance that our staff here at the CBC unit cannot perfect that rap sheet and get an accurate answer, we reach out to the candidate. When we do that, we update the system to none being processed. That's none being processed system 1. Just to give you an idea of how many times that happened in 2023, 12. We had to reach out to 12 applicants to ask for their help. So it's not happening often. Okay. The more common scenario in which you are going to get an update for that says none being processed is when the Justice Center Criminal Background Check Unit is considering directing the provider to deny employment based on the applicant's criminal history, and that we are reaching out directly to the candidate and giving them the opportunity to provide evidence of rehabilitation. Okay. In looking at this, this is 99.999% of the time you get an update for none being processed. It's likely this. In the scenario that it is not, and you have questions, if somebody remains in a being processed status for more than 20, 25 days, we could be looking at scenario one, excuse me. If that is the case, don't be afraid to contact us and ask. We'll be very, we'll be very forthcoming about what we're doing. Okay. And if we did reach out directly to the applicant for assistance on obtaining disposition information, as in this slide, we're going to tell you that. And we're going to tell you that the person's in receipt of the document. We're waiting on them. Now, when you get the update of none being processed, it is most likely to be scenario number 2 on the screen now. And the outcomes of a none being processed are either going to be a denied, a not denied, as we discussed, or the infamous update, status update of, you see the asterisk, criminal history. And we're going to discuss that after Davin asks the question.
I'm just pointing out there's 5 minutes left, so,
Okay.
that's,
All right. So if you receive an update that says criminal history, not denied criminal history, just criminal history, you're going to receive that update after a none being processed status update. This is a second status update, and this is what it means. Before considering a denial of employment, the Justice Center, as we stated, is required by New York State law to give the individual an opportunity to provide evidence of rehabilitation. Okay? The provider may only move forward with a hiring decision once that's done. The important thing to note here is the request is sent via certified mail to the address provided during the fingerprint registration process. Okay. So the way we notify the applicant that they're a potential denial is by sending the criminal history, sending it via certified mail, and giving them the opportunity within 20 days of receipt of that letter to submit evidence of rehabilitation. Okay. So what happens? Sometimes the request is either unclaimed or undeliverable. At that point, we cannot state that the person has had a full and fair opportunity to provide evidence of rehabilitation for us to consider prior to making a decision. What we will not do is make an adverse decision when we know that the person hasn't had a full and fair opportunity because they haven't received the letter. Okay. What we do at that point is we will contact all authorized persons for the provider. Okay. You will receive a notification of the status of the certified email, that it's unclaimed, undeliverable, or, that it was just not delivered. We will provide you with a notice that the background check process will not continue until there is action taken by the authorized person. It's important to note. And we will provide you with a notice that the criminal history has been uploaded to the criminal background check system for review by the authorized person. And the email and the upload will contain very explicit instructions on how to successfully request that a letter be resent to the candidate. Okay. What's important to note here is this is all against the backdrop of the status update that you have received in the CBC system that just says criminal history. Okay. Now, when you receive that update and you receive the communications and the correspondence, we require your assistance to move forward. Okay. If you are interested in hiring this person after you've reviewed the criminal history and after we've given you a status update that the mail could not be delivered or wasn't delivered, if you want to hire the person, you have to tell us in an email response that you want to hire the person, that you've reviewed the criminal history, that you want to hire the person in a direct care position because this serves to show that the person continues to be a subject individual. And you must email and you must provide us with a verified address so that we can resend the letter. If you do not respond and a person's in criminal history status, update status, you're never going to get a decision. It's going to sit there and our legal staff in the CBC unit will monitor this. And at the passage of time of 6 months, we're going to destroy the record because we assume that you haven't hired the person. What I will tell you as an authorized person is if you receive this and you have no interest in hiring, please update the CBC system to indicate that. Okay. There's a lot of ways I could go with this to demonstrate why this is important. We don't have the time today. I think we've had a lot of great questions. That's probably why we don't have the time. But just please note that red flags should go up in your head, not about the person, but about the process when you receive a status update of none being processed or the subsequent status update of criminal history. Okay. We'll touch on subsequent arrests with our remaining time. When we receive a notification of arrest, we will notify you about the arrest, so long as the person is in your employ. Okay. We got a lot of questions upon receipts of arrest notification of what do I do? Can I keep them in my employ? Do I have to fire them? The Justice Center cannot answer those questions. And to save you the time, your state oversight agency can't answer those questions. When you receive an arrest notification, the Justice Center has already verified that you have that person in your employ and that they have a substantial property interest in that employment. we're notifying you that the person's been arrested and that there's an allegation that they've engaged in some criminal conduct. And we're telling you what it is and where it occurred and the date and time at which it, or the date at which it occurred. What you do with that is this. It is your responsibility as the provider of service to take any and all steps that you, the provider of service, deem necessary to protect the health, safety, and welfare of individuals receiving mental health treatment services at your location. Okay? And we do ask that if a status update on that individual changes upon receipt of an arrest notification, that you update the CBC system with employment status.
We have 1 minute remaining, Jim.
I think we can probably get through the last topic.
Okay.
I'm gonna skip past this. To temporary approval. Providers of service have the authority under New York State Executive Law 845B to conditionally hire an individual. I'm gonna give you the highlights of what you have to do if you conditionally hire someone. You have to have a policy to ensure the health and safety of individuals in care are protected. Okay, so if you do conditionally hire someone, make sure there's a policy in place, and the policy should contain, if it contains nothing else, it should contain, number one, that you do not conditionally hire someone until you know that the person has been physically fingerprinted. Okay, it's important to note conditional hire does not allow you to hire someone and then a week later send them for fingerprinting. When you conditionally hire, that person has to have been fingerprinted. And a good rule of thumb is that before you cut that person loose in a supervised capacity with your folks receiving services, that you make sure that there is an update in the CBC system that shows that that record is in there, because that means that the fingerprint has occurred and that the person's currently pending. Please make sure that your policy states that the individual that's been conditionally hired is supervised by a manager or someone deemed qualified to provide oversight, and that that supervisor is always in the presence of the conditionally hired individual while personal care activities occur. And I'm gonna, even if I go over a minute, I think it's important for us, the authorized persons that are thinking about using conditional hire status, it is your responsibility before you conditionally hire someone to ensure that you do not conditionally hire anyone with a criminal history that includes a felony sex offense, a felony within the past 10 years involving violence, or a conviction for abandoning or endangering the welfare of an incompetent, physically disabled, or vulnerable elderly person. And hopefully the people that are paying attention, there's probably bells going off in your head. If I'm an authorized person and I'm responsible, what if the person isn't honest with me? Here is the deal I will make with you in my last 8 seconds that I have. If you conditionally hire someone, okay, please update the system before that person steps foot in your building to say that the person has been temporarily approved pending the results of the criminal history. It's a selection in the employment status update. Please do that. The reason I say that is if the criminal history results reveal a felony sex offense, okay, let's say the person has been convicted of first-degree
Stop.
rape,
Come on.
we will contact you we have processes in place where we will see that you've temporarily approved that person, and we will call you and tell you that that person is ineligible for conditional hire and that they should be removed. So if you take away anything from this, you conditionally hire someone, update them in the CBC system so we know.
Thank you, Jim. I'm sorry, but I'm glad you answered a lot of questions that people had. We have general information about, contacting us. There are some questions left on the table, but they were pretty specific to your issues. So always contact the CPC. As Jim said, he's available to answer your questions. I hear him answering questions all the time. So don't suffer in silence. Here's our contact information, and you will get this PowerPoint at the conclusion of the Justice Center Summit, and this recording will be on the website if you had to step away, and Jim is always available for your questions. Thank you all very much this morning for participating.
Thank you, Davin, and thank you to the professionals at WRI that really made this happen. It's great to have the opportunity to reach so many folks in the community. So thank you.
Thanks, everyone. Have a good day.